that will have on members of the public. The Law Society of Kenya is mandated under Section 4 of the Law Society of Kenya Act with the responsibility to protect and assist the public in all matters touching ancillary or incidental to the law. We are deeply concerned by the recent developments surrounding Direct Line Insurance, a key player in the Kenyan PSV insurance market. The sudden cessation of operations by Direct Line Assurance, as pronounced by the Royal Credit Limited chairman, S.K. Macharia, has sent shockwaves throughout the industry and raised significant questions about the protection of public interest, policy funds, and integrity of insurance services. On 30th June 2023, Direct Line held Kenya shillings 1.66 billion in gross premiums from commercial PSV covers, giving it about 60% share market in this class of business. Thus, according to the reports that were given by the Insurance Regulatory Authority at that time, IRA, similarly, in the insurance industry, is tasked with the responsibility for licensing, inspection, and control of all insurance companies. The Act grants IRA the exclusive authority to license and revoke licenses of insurance companies, given that they are regulated entities. The television announcement regarding the closure of Direct Line Assurance raises significant concerns about the regulator's position, especially since most PSVs are currently operating under Direct Line covers. Further, it raises legal, regulatory, and ethical questions that require immediate attention. 1. The intention to terminate insurance services without adequate notice or procedure appears to contravene the provisions of the Insurance Act, the regulatory framework established by the IRA, and such actions undermine the stability and trust in the insurance sector. Secondly, the proposed immediate termination of all employees without due process or consideration of their rights is a clear violation of the Employment Act. Employees are entitled to proper notice, compensation, and benefits as stipulated under the law. Third, the manner in which this potential closure has been handled raises concerns about the adherence to the principles enshrined in the law, the Constitution of Kenya, including protection of workers' rights and obligations of corporate entities towards their stakeholders. The suspension of all insurance services by Direct Line Assurance Company could leave many policyholders and the transport sector in disarray. This abrupt disruption can lead to significant economic and social consequences affecting the livelihoods of many Kenyans. The Law Society of Kenya is closely monitoring the situation and calls upon the IRA to take immediate and decisive action to address the concerns arising from the alarming statement on cessation of operations by Direct Line Assurance. This significant disruption within the Kenya PSV insurance sector necessitates urgent measures to restore public confidence, protect policyholders, and ensure the integrity of the insurance industry. We note that IRA has since released a statement negating the announcement by Direct Line Assurance. However, it's imperative that IRA takes immediate measures to investigate the challenges that are being faced by Direct Line Assurance and share a planned remedial action to ensure that policyholders are fully informed about the status of their coverage and the security of their funds, to prevent disruption in the public transport sector and to mitigate the financial risks faced by policyholders. It is of utmost importance that the ongoing shareholder disputes be resolved expeditiously. The IRA, in collaboration with the business registration services, should prioritize harmonizing their records to prevent the discrepancies and further conflicts. This involves a thorough review of the conflicting records and court decisions to establish a clear and legally binding solution. Upholding the integrity of corporate governance practices is essential to prevent similar crises in the future. In light of the impact that insurance companies have in the economy, a comprehensive review of the legal and regulatory framework governing insurance companies and corporate governance is necessary to identify and address gaps and inconsistencies that have contributed to the current predicament. Ensuring robust mechanisms are set in place to help prevent similar occurrences and enhance the resilience of the sector. We also ask that there should be immediate engagement between the IRA, Direct Line Assurance shareholders, and other relevant stakeholders, including the Ministry of Transport and the National Treasury. Why we ask for this is, if you look at this particular sector, we have Explico that last year in December we saw a notice of them going under receivership. We now have Direct Line that is taking up almost 2/3 of the public service insurance industry. And then we have Amaco. To see a situation where Direct Line goes under will be a huge loss in this industry and lead to total disarray. A coordinated approach will facilitate a smoother resolution process and minimize the impact on the public. Such collaboration will ensure the interests of policyholders are prioritized and the stability of the insurance industry is maintained. We urge ARA to take responsibility as the regulator in this sector to implement these measures with urgency to safeguard the interests of policyholders and restore confidence in the insurance industry. The Law Society stands ready to support these efforts and ensure that justice and transparency prevail in addressing this critical issue. We stand in solidarity as well with the employees that may be affected by these changes, and the Law Society is ready and willing to offer their legal support. We will continue to monitor these developments closely and advocate for safeguarding of the public interest in the insurance sector. We remain committed to advocating for the rule of law and the protection of public interests. We call upon all involved parties to act with urgency and transparency to resolve this matter swiftly and justly. On the current finance bill, and we pick 3 particular areas that we will talk about: tax certainty, cost of living, and the rule of law. So we have noted with concern the numerous proposals outlined in the bill, which appear to reverse or diminish the various exemptions and benefits that were previously established by the Finance Act of 2023. If implemented, these proposals would potentially undermine the legislative gains achieved with the Finance Act of 2023. This would in turn adversely affect the many stakeholders who have benefited from these provisions. Importantly, tax certainty is a key tenet of tax systems, and the continual addition and removal of provisions effectively erodes this certainty, ultimately undermining investor confidence. The stability and predictability that investors and businesses rely on to make long-term decisions is compromised by certain provisions in this bill. By way of example, the bill proposes to increase the excise duty rates applicable to the telephone and internet data services as well as money transfer services from 15 to 20%, which was notably reduced under the Finance Act 2023. The bill also proposes to increase the rate of import declaration fee, IDF, to 3% from the current rate of 2.5%. The bill has proposed the removal of various exemptions that have been in place by the Finance Act 2023, including in relation to electric vehicles, motorcycles, buses, and bicycles, which were put in place in the Finance Act 2023. Now, these are just a few examples of the clawbacks and the lack of stability in the tax regime in our country, and failure for us to agree and sit and have a tax regime that is stable will ensure that foreign direct investment is not attractive in this country. We hope that the Department Committee on National Planning and Finance will consider all the proposals submitted by the stakeholders to create tax certainty. On the issue of cost of living, the bill introduces various provisions that will increase the cost of living for many Kenyans, which the LSK finds problematic. The various proposals in the bill will make life more expensive for a significant portion of the population, adding financial strain to already burdened households. We believe that some provisions in this bill will lead to greater economic hardship and inequality. We take note of the proposal in the bill to impose motor vehicle tax at the rate of 2.5% on the value of the motor vehicle, which we view with great concern. The likely negative impacts which we expect to see include an increase in the cost of insuring vehicles and a reduction in motor vehicle insurance uptake. Further, this tax will have a negative impact on the transport and logistics industry, leading them to pass on the additional cost to the customers, thus escalating the cost of living through a multiplier effect. Notably, vehicles are no longer luxuries, and so an annual motor vehicle tax will place a disproportionate burden on lower-income households, especially those that rely on motor vehicles for their living. The motor vehicle tax will lead also to an increase in the operating costs of manufacturers and their suppliers who utilize vehicles for commercial and agricultural purposes. This additional operational cost will make businesses less profitable and result in higher prices for consumers. Overall, this tax will have a widespread and detrimental effects on both consumers and businesses, as it's a proposal that should be deleted. Additionally, the bill proposes to increase excise duty rates from 15 to 20% on the telephone and internet data services, fees charged for money transfer services by banks, money transfer agencies, and other financial service providers, as well as fees charged for money transfer services by cellular phone providers. Once again, this proposal will have the effect of increasing the cost of living and push many Kenyans to a cash-based economy. The bill also proposes to introduce an eco-levy on certain goods and products listed in the 4th schedule of the Miscellaneous Fees and Levies Act, including office machines, calculating machines, telephone sets, including smartphones, essential packaging, plastics, rubber tires, and diapers. This proposal will disproportionately increase the cost of living for Kenyans and raise the cost of doing business for manufacturers and importers in Kenya. Further, the bill proposes repealing Section 14 of the excise duty, which allows licensed manufacturers to offset excise duty incurred or paid on exercisable goods imported or manufactured in Kenya that are used as raw materials in manufacturing other exercisable goods. Section 14(2) of the Excise Duty Act further allows licensed persons who purchase internet data services in bulk for resale to offset the excise duty paid on the bulk purchase against the excise duty payable on resale to the final consumer. The relief provided in Section 14 of the Excise Duty Act allows manufacturer of exercisable goods to claim the cost of that excise duty on raw material payable on the sale of the manufactured exercisable goods. Deletion of the same will increase the cost of goods, as manufacturers will likely pass on this excise duty incurred on raw materials to consumer. And if passed, this provision will increase the cost of exercisable goods. And we have also shared an extensive, we'll also share with you an extensive submissions that we made. Under rule of law, we have two major concerns. One is the proposal empowering the commissioner to automatically disallow a taxpayer's objection if the taxpayer fails to provide the requested information within a specified period. This proposed amendment grants excessive power to the commissioner, potentially leading to unfairness and hindering access to fair hearing for taxpayers. Additionally, it removes the taxpayer's right to appeal to the tribunal if the commissioner decides to disallow the taxpayer's objection, given that the provision in its current drafting does not require issuing a formal decision, leaving taxpayers with no recourse for appeal. Further, we have taken note of the proposed removal of the prohibition on the commissioner for issuing agency notices when a taxpayer appeals to the Tax Appeals Tribunal or the High Court, which raises significant concerns about the rule of law. If enacted, this proposal would allow the commissioner to enforce tax collection of disputed taxes through agency notices, even when a taxpayer has appealed against the tax in dispute. This situation would lead to injustices, as taxpayers may be compelled to pay taxes under dispute without a fair resolution in the appeal process. We are of the view that the current drafting of this provision undermines the principle that no one should be condemned unheard, and may render the appeal process ineffective, forcing taxpayers to incur additional legal costs and time to seek court intervention to halt enforcement action. Lastly, we take also note of the proposal to exempt the processing of personal data by the KRA from the provisions of the Data Protection Act 2019, where the disclosure is necessary for assessment, enforcement, or collection of any tax or duty under written law. In our view, the proposed unlimited access to personal data without court orders or proper procedures will infringe upon taxpayers' rights to privacy and pose a risk of data misuse. For this reason, we consider such a move unconstitutional and a violation of the rule of law. Additionally, the importance of public participation as enshrined under our Constitution cannot be overemphasized. As the Parliamentary Committee continues collecting views from the public, we urge them to actually consider those views. The whole purpose of using taxpayers' coffers should not be as a mere exercise of sitting and talking and wasting time, but they should actually take into consideration the views that have been made by the various parties, and failure to incorporate the views of citizenry will see the Law Society of Kenya as gatekeepers of the rule of law without hesitation seek the necessary legal redress. However, despite criticism that we have raised, as the Law Society, we commit that we are open to working with the necessary government institutions to assist them uphold the rule of law, and that at the end of the day, our aim is both to ensure that we protect the interests of the members of the public